to Lincoln College, Oxford, England. He returned to Bombay and started his career at the bar, where he practiced for 19 years from 1922 to 1941, before being elevated to the bench. Justice Chagla was the first Indian Chief Justice of the Bombay High Court after India attained independence in 1947. He was a professor of constitutional law at Government Law College, Bombay in 1927. He was one of the most eminent legal luminaries to grace this country. This moot court competition is held in his honor. If the judges are all right with it, we will now be commencing with the final rounds.
Oh, yes.
Good evening, Your Lordships. I am J1, Speaker 1, speaking on behalf of the petitioner in the case of XYZ and others versus the Union of Rashtra. Would Your Lordships like a brief synopsis of facts before I proceed with my contentions?
No, I'm okay. You can take that as read. Unless Justice Ahuja.
No. I'm also. Please go.
Okay. Much obliged, Your Lordship. I will be dealing with the first issue in the present proposition today, that the order dated 1st June 2021 is ultra-biased, the Constitution of Rashtra, because firstly, it does not satisfy the test of proportionality. Secondly, it has a chilling effect on free speech. And lastly, it violates the principle of federalism. Firstly, with respect to the test of proportionality, it is submitted that while freedom of speech and expression and right to life under Articles 19 and 21 of the Constitution are subject to reasonable restriction, such restrictions cannot be of an arbitrary or excessive nature. This was recognized by the court in Shreya Singhal versus Union of India. Thus, the proportionality test, as has been evolved by the court in KS Puttaswamy versus Union of India, is sought to be applied. The test is a cumulative requirement, which means all 4 prongs of the test must be satisfied for the order to be considered proportionate and therefore constitutional. It is presently contended that the 2 limbs of the test which are not satisfied by the present order is that the extent of interference should be proportionate to the need for such interference. And secondly, the order should contain procedural guarantees to prevent its misuse. Firstly, with respect to the disproportion of such a restriction, I will be arguing this in a 3-fold manner. Firstly, that state governments have been brought within the order, and this is therefore a disproportionate impact on their rights. Secondly, the present order does not satisfy its underlying purpose and disproportionately impacts the rights and lives of citizens. And lastly, less restrictive alternatives were available to the center in the present. Firstly, with respect to state governments, it is the order under subclause A brings state governments within the ambit of restrictions placed by the order. This is disproportionate for 2 reasons. Firstly, the center receives its information from states and publishes the same online or otherwise, and does not perform any independent role in verification. The center's facts are the same as the state's facts because the states are the first responders to a crisis situation, and being aware of the on-ground reality of it are the ones who perform the independent role of verification. Therefore, if the underlying purpose of the order is to curb misinformation with regards to the pandemic because it derails its effective management, then such a measure is antithetical because it restrains states from publishing vital information that changes every hour and thereby derails their efforts to effectively manage the pandemic. Your Lordships, it is submitted that in a crisis that we are currently facing, which is of a public health nature, the facts and circumstances or the restrictions that the center is seeking to impose are of a nature which change at all points of time. The number of hospital beds available, the medical oxygen that's available, the infection and fatality rates do not change on a daily basis. They change on an hourly basis. It is important for the states to be given the autonomy to publish this information or share this information promptly so that it can actually enable its citizens to go ahead and access this information effectively and save lives. This restriction, therefore, disproportionately impacts that ability of states. Next, it is argued that the present order does not satisfy its underlying purpose and also disproportionately impacts the rights and lives of citizens. It is submitted that the order was enacted to curb misinformation. However, it is to be noted that no control over information disseminated online by international media organizations or international government bodies has been instituted, nor can it be instituted. Such bodies have often reported divergent information to official government sources and highlighted that there is a trend of underreporting of cases by governments across the world. This has occurred in cases of in the countries of Brazil and India. Access to such information is available to the citizens because international media reports are still something that citizens can go ahead and access because it is not brought within the scope of restrictions under the order. Therefore, such divergent reporting can still have the effect of causing mass panic and hysteria amongst the people. But on the alternative, what necessarily needs to be taken into account is the positive impact that information has in playing a protective role within a democracy, especially during periods of crisis. Your Lordship's attention is brought to paragraphs 11, 12, and 14 of the petitioner's memorial, where in the case of redistribution of supplies, of essential supplies during a pandemic, the Supreme Court has noted that free flow of information essentially has a protective role in the towards safeguarding the lives of citizens. This can be seen in the current scenario as well, wherein government reports are often inaccurate or not up to date. In this regard, the citizens step in to fill the gap or the vacuum of information that exists by going ahead and sharing this information online or through other channels. Such citizens are first responders such as medical health professionals, etc., journalists, etc., who have a ground reality idea of what is essentially going on. Such information has been recognized to play a vital role in actually going ahead and saving lives and providing resources to individuals at a point of time at which central and state resources were not adequate in providing the same. Therefore, this has a very direct impact on the right to life and personal liberty of individuals because they are curtailed from disseminating or accessing information, positive information, just because it is divergent to what the central report might be at that point of time. Therefore, it is submitted that at the end of the day, the order does little to prevent mass hysteria caused due to divergent reporting because such divergent reports can also be accessed through international media channels or international organizations. But the positive impact that the information that people publish online has towards saving lives is necessarily curtailed by this order. Therefore, Article 21 is necessarily infringed and people's rights are disproportionately curtailed in this regard. Lastly, it is contended that less restrictive alternatives were available to the center in order to prevent the plague of misinformation that is occurring during this pandemic. Firstly, it is noted that there exist several other provisions as well, which can place post facto safeguards to ensure that there is no dissemination of false information online. This takes the form of Section 54 of the Disaster Management Act. I direct your Lordship's attention to the petitioner's memorial, where it has been stated that people can be imprisoned or fined if they are found to be disseminating fake information online. Furthermore, the IT intermediary rules of 2021 also allow the center to direct social media intermediaries to take down any kind of information which is found to be fake.
Council, just a moment. This is a situation of national disaster, and the disaster has to be managed. If we start going into the IT Act and the provisions or the facilities available under those acts, we may not have been able to avert this kind of a disaster. So could you please address your arguments towards the definition of disaster and disaster management under the NDMA? Would you be in a position to do that?
Yes, sir. the definition of disaster and disaster management is all such measures that can be undertaken for preparedness, capacity building, and the effective mitigation of a disaster. But if such measures undertaken do have a disproportionate impact on the rights and the lives of citizens in
And
such a way that it
who
actually
decides that?
improves life.
Who decides that?
So that is evaluated on the basis of the facts and circumstances of the case and by the court, which is why we are present before you today.
And if there were two bodies involved trying to ascertain and decide the facts and circumstances, would you be in a position to avert that disaster?
I'm
The
sorry.
time taken is very important.
Precisely, sir. The time taken is very important, but information too is time sensitive. The designated officer in this case can take up to 3 days time to give approval for divergent information that has been published online. That is sought to be published anywhere. Now, such information has already become obsolete within 3 days of time. But to give you an example, that information could have saved someone's life. If the center it is impossible for the center to keep track of every single ICU bed that gets vacated during a particular hour, or suddenly if some medical health infrastructure like oxygen is available. But a person who is in that hospital, who knows what is going on and wants to give that information to the people.
Yes, you have a point. So would you not then think of pursuing a remedy where you would like to read down the provisions? Let's say bring down the 3-day period to few hours or something, rather than trying to get the whole thing knocked off.
So the reason we want the order to be struck down as a whole is because we don't think that it even in the circumstance where procedural safeguards may be given to the people, we think the order in and of itself does not actually satisfy its purpose of curbing misinformation in a way which is effective for the people. That is to say that information can still be accessed through international forums, firstly, but secondly, also a blanket restriction on information, even if it is for a few hours, can have something that is can have a very necessarily disproportionate impact on the lives of citizens. But even if your lordships are not satisfied with this argument, it still remains that the designated officer does not have that there is no right to representation or any period of censorship that has been prescribed within the present order. It is well noted that no period of censorship can last indefinitely. Even during periods of emergency, it is only established for a 6-month time period. Even the lockdown was only instituted for 3 weeks at a time and then extended. The order does not place any such restriction or any such time limit within which it expires. But also secondarily, it doesn't provide for any right to representation before the designated officer. The union government is given absolute control over what information can be published or cannot be published. There are no two ways to it. There is no way for you to go ahead and have that information published if the designated officer simply rejects that requirement. But also necessarily why we think a blanket prohibition on information is something that needs to be struck down at all points of time is because it also has a chilling effect on free speech. The Shreya Singhal case has recognized that this is something that renders an order unconstitutional. Note that reporting by media organizations and criticisms of management of the pandemic include statistics, facts, and figures. But at the point of time at which and an imperative part of criticizing a government's managing of the pandemic is holding them to account. And the way you hold them to account, one way for you to hold them to account is to go ahead and reveal instances where the government has withheld vital information or has gone ahead and underreported cases. In the present case, if a divergent report emerges which shows that the government has underreported cases, I need to go to the designated officer to get approval to have this information published. There is no guarantee that I will get such an approval, considering the judge, jury, and the executioner at all points of time is the central government itself. Therefore, it does have a chilling effect on free speech, because how can I possibly criticize the central government for mismanaging the pandemic if I can't go ahead and reveal instances where it has underreported? This order specifically does not allow me to do that. Therefore, it has to be read down. Therefore, it has to be struck down in its entirety. And the provisions cannot be read down to give it a more reasonable meaning. Lastly, if your lordships permit, I will move on to the contention of federalism and how this is against the base, how this order is against the principle of federalism. It is well settled that although more power is conferred upon the union under the federal scheme, that does not mean that the state's powers can be arbitrarily subverted by the center. Reference is made to the petitioner's memorial, where in S.R. Bamai versus Union of India, it has been recognized that a broad and plentiful interpretation should be given to entries in the state list so as to not dilute or whittle down their powers. In the present circumstances, the order specifically deals with dissemination of information with respect to public health, availability of medical health infrastructure, oxygen, resources, etc. This subject falls within the exclusive legislative domain of state legislatures under entry 6 of list 2 of the 7th schedule, public health and sanitation. In the present case, dissemination of information with respect to public health, therefore, is something that the state necessarily needs to have the power to do for it to exercise its legislative powers and executive powers. The order specifically curtails on the state's powers to do so, and therefore violates the principle of federalism. Therefore, in light of
Also, just a moment.
Yes, sir.
This is a situation of national disaster.
Yes, sir.
Of course, it relates to public health. So, where does national disaster fall in? List 1, list 2, or list 3?
So, disaster management as a subject does not occur within any of the 3 lists mentioned in the 7th schedule. But a lot of what disaster management has to do with, the predominant subjects are within the state legislature. This includes public order, police, public health and sanitation, trade and commerce, agriculture, water supply. All of these subjects fall within the state legislature. Predominantly, the subject of disaster management is something that state legislatures have not only historically had the power to legislate.
All right, let's look at it differently. This is a pandemic. It has affected the whole world. So how would you look at it? Is it a national disaster or is it a state disaster? How would you look at it?
It's a national disaster, sir. But that does not mean that states should not be given autonomy, or that that it is not necessary for states to have a certain degree of autonomy even during a national disaster. That's because states are the have assessment of the ground reality situation. And even a national disaster
such as... over time, we have other counsel to deal with as well.
Yes, sir. If I may just finish answering.
Our extension is already exhausted.
Okay, sir.
You'll have to yield to your fellow counsel.
Okay. Thank you, your lordships. I finally submit that based on the arguments I have made, the order is ultra vires the provisions of the Constitution of Rashtra. Thank you.
If your lordships permit, may I begin?
Yes.
Thank you. Good evening, your lordships. I am Counsel J2, appearing on behalf of the petitioner in the case of XYZ versus Union of India. I will be dealing with the following 2 issues. Firstly, that the order is ultra vires the Disaster Management Act. And secondly, that Section 6 of the Disaster Management Act is ultra vires the Constitution of Rashtra. Beginning with my first issue, I will be making the following 3 submissions. Firstly, that the Act does not empower the NDMA to issue such an order. Secondly, that the order defeats the provisions of the Act itself. And thirdly, that the order is manifestly arbitrary. Beginning with my first argument, the order was passed under Section 6, subsection 2, subclauses A and I of the Disaster Management Act. These clauses are extremely vague and offer unlimited power to the National Disaster Management Authority. They only talk of laying down policies on disaster management and any other steps which the NDMA may consider necessary for its functions. But no specific provision on information appears in Section 6 as entirely. Here I make reference to the case of Delhi Laws Act, which is cited at paragraph 43 of the memorial, wherein the Supreme Court held that the extent of delegation of legislative powers is a prerogative of the legislature. However, the legislative policy must be laid down with sufficient clearness. In the present case, there is no clarity on exactly what the National Disaster Management Authority is empowered to do. Here, I also make reference to Section 54 of the Disaster Management Act, which acknowledges the penalty for issuing false warnings, which this has been stated at paragraph 45 of the memorial. However, existence of such a section means that the legislature is acknowledging that in case of a disaster, false information is likely to exist. And despite making this acknowledgement, the legislature has explicitly not given this power to the National Disaster Management Authority. As broad as the section is, such a power cannot be imputed into its meaning without sufficient clearness being present. I now move on to my second argument that it takes authority away, which is granted by the Disaster Management Act. The Act under sections 31 and 24K empowers the District Disaster Management Authority and the State Executive Committee with the positive duty of disseminating information during a period of disaster. However, under the present order, this means that these authorities, being statutory bodies, need the permission of the national authority in order to carry out a duty that is given to them by the statute, parent act itself. This is in stark contravention to the ratio in the case of Ajay Kumar Banerjee versus Union of India, wherein it was held that there is no unlimited right of delegation and no enactment can go beyond the parent act itself. My third submission here is that the order in itself is manifestly arbitrary. It is arbitrary to such an, as my co-counsel has already dealt with this issue, I would just like to expand on it in one further manner in the question of procedural safeguards, that even in case the designated officer fails to supply an approval or a refusal of the request to disseminate information within the designated period, this order still does not permit the applicant to go ahead and publish that information. As your lordship rightly addressed the question of even if it was reduced down to a few hours from 3 days, this question is still not solved. If within those few hours, the designated officer does not issue approval, the applicant is still not permitted to disseminate that information because they do not have the approval. And in this case, it is still rendered pointless to issue it after the relevant time has expired. So, based on these submissions, and in addition to my co-counsel submissions, I contend that the order is so manifestly arbitrary that the court is able to come to a conclusion that such a broad power was never conferred upon the authority in the first place. I also place reference upon the principle of constitutional morality to contend that the legislature cannot give powers so broad to a particular body in such a manner that they are empowered to curtail fundamental rights in any way and manner they see fit in a disproportionate and excessive manner. In light of all of these arguments, I therefore contend that the order is ultra vires the Disaster Management Act itself. I now move on to my next issue, that the Section 6 is ultra vires the Constitution of Rashtra. Here, I will make the following three arguments. First, that the section impedes on the exclusive powers of the state legislature. Secondly, that it does not pass the test of harmonious construction and pitch and substance. And thirdly, that the Section 6 is arbitrary due to lack of requisite checks on the power of the National Disaster Management Authority. Section 6 is a broad provision which empowers the NDMA to lay down policies, plans, and guidelines for effective disaster management. It also has the function of formulating the national plan, and along with this also has the function of giving binding guidelines to states which they must follow in order to prepare their own state plans. It also has the broad power of taking any such measure as it may consider necessary to deal with the disaster. As contended at paragraph 47 and 48 of the memorial, Article 246 of the Constitution of Rashtra provides exclusive powers to state legislatures for subjects which fall within List 2 of Schedule 7. As my co-counsel had begun to deal with issue, let me elaborate on that. Although disaster management is not contained in one particular list in the Schedule 7, it affects a wide range of subjects listed down under the schedule. However, most of these subjects fall within the purview of the state list. To name a few: public order, police, local government, public health and sanitation, burials and crematoriums, communications, agriculture, water supplies, trade and commerce, etc. It is therefore clear from this that all of these are matters on which a disaster has a direct effect, thus meaning that a state government is the first responder to any disaster. Therefore, it is necessary that a state government has a relative degree of autonomy to deal with the disaster in a manner which the needs of the state may require. Here, I also give you a few examples to substantiate my contention. The state of Kerala had been performing consistently well in terms of infections and fatalities. However, it was still not permitted to relax restrictions for the sole reason that the central government had not permitted it to do so. And therefore, there was an effect on the trade and commerce of the state, which the state government then had to absorb. Further, to give you another example, not every crisis is going to be a global pandemic. There might be state-specific crises which affect only a particular part of a particular state. But even in those cases, state governments do not have the authority to act on their own. Here I make.
Why do you say that?
Because, Your Lordship, the state plan must be prepared on the basis of a national plan, and any guidelines issued by the national authority must be followed by state authority in taking any measures for a disaster. This is under Section 6 of the Act.
I'm looking at Section 6. Where do you get this from?
Yes, Your Lordship, just a second.
The suggestion in Section 6 is not that the states can't manage their own domestic disasters, just that if there is a plan for disaster management which is state specific, it may require an approval from the center, because states often require support from the center. That doesn't necessarily make it ultra vires. And what you have done here in this argument is that you are saying that disaster management is not in any of the lists, but its components, one or more of its components may be in list. Therefore, the whole of it is a state subject. Now, that surely cannot be. This is a pandemic that affects every state and the states together, because if something happens in Maharashtra, it affects states in Goa, Karnataka, Andhra, Rajasthan, Madhya Pradesh, almost everything that we share a border with. That elevates it to the level of a national disaster. How is that? How is the statute ultra vires?
Much obliged, Your Lordship. However, I submit that the statute does not only deal with a pandemic. It deals with a wide variety of disasters which may occur, and it does not make any distinctions between the scales of the disaster. So, now, Section 6, read with other provisions of the Act, mandate that directions issued by the national authority are binding upon the state legislature. If I may give you an example, in the 2013 case of Uttarakhand floods, the national authority, despite the Act having been in place for nearly 10 years, had not formulated a national plan and had not issued any guidelines to the state governments. In the absence of a national plan.
That's not a ground to hold it ultra vires. The fact that a statute is being abused or not used or is fallen into disuse is not a ground to invalidate it.
Your Lordship, even if you are not satisfied with this, I will in the further arguments, I will substantiate on how it has no checks and thus it is readily open to abuse.
But that's not a ground for invalidation.
Your Lordship,
the fact that that's well settled law, constitutional law, that just because the statute is liable to be abused is not a ground to hold it unconstitutional.
Your Lordship, it is not simply liable to abuse, it is arbitrary in such a manner
that's
that
it must. Argument. Which is the one you're making?
That is the argument.
Are you advancing the argument of manifest arbitrariness, or are you saying it is ultra vires because it is liable to abuse? Which is it?
Your Lordship, I'm contending that the section itself is arbitrary.
All right.
Much obliged, Your Lordship. So, as I stated before, the Disaster Management Act, to address your question also, while it is not exactly contained in any of the three lists, the most part of the effect that a disaster has is contained within the state list. Therefore, according to the doctrine of pith and substance, it is not simply an incidental encroachment. It is taking powers that are vested exclusively within the state legislatures away from them and assigning it to the national authority. To substantiate on the argument of arbitrariness.
Just one minute, Counsel. Your colleague said that disaster is not listed in any of the entries. There is an entry 97 in list 1, which says that if it is not listed anywhere, that power is with the union.
Your Lordship.
You should consider that part also in your arguments.
I appreciate that, Your Lordship. However, the Act was enacted under entry 23 of the concurrent list. the center did not choose to use this power. Rather, it used the concurrent list to enact the act under social security and social insurance. Moving on, Your Lordship, addressing the question of arbitrariness, it is settled law in Shaira Banu versus Union of India that any legislation, whether plenary or subordinate, can be challenged on grounds of arbitrariness. Here, I also place reference on the case of Srilekha Vidyarthi versus State of Uttar Pradesh, wherein it was held that if there is no impediment to exercise of power under a legislation, then this attracts the vice of arbitrariness. In the present case, the section contains no procedural safeguards, and it is to protect the section against abuse of power by the national authority. It is contended that it is not impossible for an act made for disaster management to possess any procedural safeguards. And to substantiate this argument, I place reference on the Civil Contingencies Act of 2004, which is in force in the United Kingdom. That act identifies different scales of emergency and limits the rule-making power of the Crown only in cases where the state bodies and the local bodies are not able to handle the situation. Even while giving rule-making power to the Crown, it limits it only to circumstances where the situation is urgent, where it is necessary to enact such a rule, and when existing legislation is not sufficient to tackle the crisis. However, the Disaster Management Act does not contain any of these procedural safeguards. It is not my contention that this the Civil Contingencies Act is directly applicable, or that it should be done just because a different country does it. I am using it to contend that I just need one more minute to conclude, Your Lordship. If you may please allow me to do that.
Yes.
Thank you. Much obliged, Your Lordship. It is not my contention that this is directly applicable. I am using this to contend that it is possible to have procedural safeguards so as to ensure that there is a harmonious construction which allows separate and distinct powers to the state and the national authority. Now, here I also place reference on the Epidemic Diseases Act, which follows this distribution of power and gives most of the decision-making powers within the borders of the state to the state authorities, and only limits the powers of the union to situations where it is required to prevent the virus from spreading from one state to the other. However, the decisions within a state are taken by the state government. Therefore, I submit that there is a possible harmonious construction, and this taken along with the fact that the section itself possesses no procedural safeguards renders the section arbitrary and therefore ultra vires the Constitution of Rashtra.
Thank you.
Thank you for your kind and patient hearing, Your Lordships.
A very good evening to the honorable judges of the court. This is counsel number 1 appearing on behalf of the respondents in the case of X and others versus Union of Rashtra and others. The counsel seeks permission to collectively refer to this bench as Your Lordship.
Yes.
Much obliged, Your Lordship. It is to be noted, Your Lordships, that counsel number 1 will be addressing issue 1 and 3 for 15 minutes, and counsel number 2 will be addressing issue 2 and 4 for a time period of 15 minutes. Your Lordships, with regards to the jurisdiction, the petitioners have approached this Honorable Supreme Court under Article 32 of the Constitution of Rashtra as a public interest litigation. The respondents humbly submit to the jurisdiction of the court and will argue on merits. Your Lordships, if Your Lordships are well versed with the facts of the case, yes, the counsel would much oblige Your Lordships. It is Your Lordship's honor to present before, it is your counsel's honor to present before this court the following submissions on behalf of the respondents. First, in order to test the validity of a delegated legislation, 2 challenges are required. Either it should violate the provisions of the Parent Act, or secondly, it should violate the Constitution. In the present case, the counsel submits that first, the order does not violate Article 19 of the Constitution of Rashtra, as the order is a reasonable restriction under 19 Clause 2. Secondly, the order does not violate Article 21, as the order safeguards the right to health enshrined under it. And lastly, the order dated 1st June is intra-virus the provisions of the Disaster Management Act, as the order has been issued within the statutory provisions of the Act and is also not manifestly arbitrary. My co-counsel will argue that the order does not violate the principles of federalism and that Section 6 of the Disaster Management Act is not unconstitutional. Turning to our first submission that the order is not violative of Article 19, Your Lordships. At the outset, if I may draw the kind attention of the court to State of Tamil Nadu versus P. Krishnamurthy at page 23, paragraph 12 of the compendium. Here, the council would like to submit that there is a general rule of a presumption of a constitutionality of a delegated legislation. With this in submission in mind, the council would like to move on to the first limb. Moving on to the first limb, the order does not violate Article 19, as firstly, panic-induced fear has caused public disorder, which is a restriction under 19 Clause 2. And secondly, the order is a reasonable restriction as it satisfies the test of proportionality. At the outset, Your Lordships, under point 1, it is submitted that Article 19, subclause 1, subclause A, is not an absolute right and is subject to the reasonable restriction in 19 Clause 2. The present order has been issued as a public order restriction. My lords, Your Lordships, epidemics and pandemics disrupt the public safety, especially when misinformation is rampant. Hence, the order has passed to ensure the prevention and mitigation of the negative effects of misinformation.
Sorry, what misinformation?
Your Lordships, misinformation of COVID-19 related matters.
Generally.
Indeed, Your Lordship, with regards to...
Everybody is only disseminating misinformation. Nobody
Indeed.
gets it right except the central government.
Indeed not, Your Lordships. However, it is to be noted at paragraph 4 of the Moot proposition, there was several inconsistent reporting. Yes, paragraph 5, much apologies, Your Lordship. There was no uniformity in terms of reporting amongst media organizations, even in respect to COVID-19 treatment protocols. And there were also inconsistent reporting regarding statistics and also in terms of infection rates and deaths. Therefore, these are the matters that we...
Divergent meant that your claims that we were doing better than the rest of the world, people started questioning. That's not divergent. That's taking on the government.
Indeed, Your Lordships. However, the most important part of the paragraph is as to say that there was no uniformity across media reportings, even in respect to COVID-19 treatment protocols. This is a grave measure which needs to be addressed, because when a person relies on inconsistent treatment protocols,
what's the check if your information is wrong?
Your Lordships.
What happens if your information is wrong? That means everybody gets treated to the same level of misinformation as long as it comes from the central government.
Indeed not, Your Lordships. The main essence of the order is to ensure misinformation is regulated and curbed from the normal dissemination of information, because the effects of misinformation undermines the effective management of COVID-19, which is why the order has been passed in the present.
Your notification does 1st June doesn't say anything of the kind. How does it do that?
Your Lordship,
you have to listen to what we say. It doesn't. There's no nexus between that and the actual handling of the COVID-19 pandemic. Nothing. What's the connection?
Your Lordships, when a person relies on misinformation, it directly impacts the safety.
Which person has relied on what information?
Your Lordships, the citizens, Your Lordships, the citizens and the people of the country of
that is inaccurate.
Your Lordships.
How does this prevent it?
Your Lordships, because it's regulating it at the source, Your Lordships. Misinformation.
Sorry, carry on.
Indeed, Your Lordships. Your Lordships, therefore, the order is passed on a public order restriction. And secondly, the order is a reasonable restriction under the test of proportionality as contended by the petitioners. Your Lordships, as per the test of proportionality, 4 prongs have to be satisfied. However, in the present case, there is all prongs are met in this circumstance. Therefore, the order is proportional. First, there is a legitimate state aim where the order has been passed so as to curb the spread of misinformation in this current health crisis. Your Lordships, it is to be noted that the state is just not fighting a pandemic, but also an infodemic, which is therefore extremely necessary to reduce the state of panic. The order is also rational as it has been issued to fulfill the objects of mitigating the spread of the virus and preventing the derailment of COVID-19 management. Thirdly, Your Lordships, the petitioners contend that Section 52 and 54 are less intrusive measures. However, Your Lordships, it is to be noted that Sections 52 and 54 only tackle misinformation when it's spread deliberately. The present order attempts to regulate innocent misinformation from being spread without resorting to criminal sanctions. Thus, this measure is the least intrusive measure that can effectively tackle the spread of misinformation at the source. And lastly, the balancing prong is maintained as the government cannot remain as a mute spectator when misinformation spreads. The present order does not impose a blanket ban on Article 19(1)(a). Instead, merely regulates misinformation which is detrimental to the interest of public and specific to the subjects under Clause 1 of the order. Hence,
just 1 minute.
Indeed, Your Lordships.
If it takes 3 days for the nodal officer to come and tell you what to do, you would have lost so many lives.
Correct.
Your Lordships, to address this question, 3 days is just a threshold, Your Lordships. However, the designated officer will work as quickly as possible to disseminate this information as stated by the council. This 3 days is just a threshold, Your Lordships. Therefore, he can disseminate the information within 3 days.
The scientific basis of this 3 days.
Your Lordships, it is just a threshold, Your Lordship, that is established by the legislature.
All right, go on.
Indeed, Your Lordships. Your Lordships, therefore, the petition. Furthermore, Your Lordships, the order is therefore proportional and is also a reasonable restriction, then hence valid under Article 19. Your Lordships, I would also like to go on to the next limb that the order does not violate Article 21 of the Constitution. In the present case,
could you stop the screen sharing if you're not using it? It's very distracting.
Indeed, Your Lordships.
Thank you.
Your Lordships, moving on to the second limb. It is submitted that under Article 21, the state has a positive duty to ensure the safeguard of life and liberty of all people. However, when people act on misinformation, it poses a grave problem which affects the safety of the public. Your Lordships, misinformation and fake news plague the internet and is harmful to the physical and mental health of the people. It creates chaos where people make uninformed decisions which are detrimental to the interests, and it also leads to poor observations of health and safety protocols. Therefore,
these general phrases are all right for political platforms. They don't carry much weight in a court of law. When you keep saying this in generalities, that people rely on the internet, everything on the internet is fake news, and people suffer, what exactly do you mean? This is what Justice Ahuja asked you. What's the basis for this?
Your Lordships, if I may draw the kind attention of the court to the judgment of Alok Alak Srivastava versus the Union of India. The court observed that fake news had led to the miseries that was towards the migrant laborers, as well as led to their demise. The court also clearly observed that fake news and the menace of fake news cannot be overlooked and had to be addressed sternly as possible. And the basis of such an order has been passed because of the inconsistent media reportings related to COVID-19 matters. Your Lordships, the interplay between Article 19 and 21 establishes that the right of the health and the safety of the people is only protected if they can act on true and reliable information, Your Lordships.
What's the check against fake news emanating from you?
Your Lordships, in this circumstance, the government, as per the Ministry of Health, has several manners by which the information has been vetted, and the information being vetted is only then disseminated to the public at large. And as well as Your Lordships, Ministry of Health is one of the nodal ministries dealing with the pandemic, especially.
First June circular doesn't say anything of the kind.
Your Lordships, the order is subject to the provisions of the Act, Your Lordships. And also the NDMA in itself is published
Mr. Counsel,
Indeed, Your Lordships.
Just consider this. This is a global pandemic. This has affected the entire nation as far as India is concerned. Why don't you consider having a national body which also has a council, which also has the state representatives and take decisions jointly?
Indeed, Your Lordships. In the present case, the order has been passed so as to ensure uniformity in all the decisions, Your Lordships. Therefore, even if you were to bring in a different body altogether, it would not, in the present circumstance, the immediate nature of why misinformation had to be curbed was therefore the order has been passed. In Your Lordships, furthermore, it also has to be noted that under section 2E of the Act, it clearly establishes that this is a disaster of national importance because the state does not have the current coping capacity to deal with it, which is why the measures have been introduced to have the Union of Rashtra as well as the NDMA having a supervising authority and also ensuring that misinformation is removed from the circulation of in the circulation of the country. If Your Lordships have no further questions, may I move on to the next contentions?
Yes.
Indeed, Your Lordships. My Lord, Your Lordships, the petitioners also contended that the order was issued on a mere opinion, and furthermore, the order is also having lack of procedural safeguards. However, Your Lordships, the order has been passed after the assessment of a situation. In the present case, panic-induced fear is a scientifically accepted phenomenon in disaster psychology. Already, as observed in Alok Alak Srivastava, that fake news and the menace of it cannot be overlooked. In the present case, the NDMA formulated the order as there was inconsistent media reportings. Secondly, Your Lordships, the government also conducted press releases and press briefings, showcased that it was aware of the ground realities that panic and fear were spreading amongst the general public. And your lordship, section 7 also clearly indicates that the national authority is advised by an advisory committee consisting of experts under the field of disaster management and those having practical experience of the same. And furthermore, social media aggravates the spread of misinformation due to the ease of convenience of access and the large number of people who use it, which is why the above mentioned points indicate that the NDMA has formulated the order on a rational opinion, on an informed opinion, and thus the order has been passed. Secondly, the petitioners contend that there was no procedural safeguards and principles of natural justice are not being met. Your lordships, if I may direct this honorable court to clause 4 of the order, the designated officer must record reasons upon rejection of the requests. Therefore, this is a sufficient safeguard as a procedural safeguard. And furthermore, in the case of Maharashtra State Board of Education, the court clearly established that recording of reasons is an implicit component of principles of natural justice. Your lordships, with regards to the contentions of the petitioners on the lack of representation, the person is already making a representation by submitting this request to a designated officer. And that is when the designated officer relies on this information. It is to be noted that the officer only plays a clarificatory role as he merely attempts to clarify whether the information is accurate or not. Your lordships, therefore, the order and the present order ensures that there are procedural safeguards and also that the designated officer is working with policies and guidelines, which is why the order should stand true and constitutionally valid, your lordships. If your lordships may kindly permit me to continue to the last submission.
Yes, you have about 3 minutes left to go.
Indeed, your lordships. Your lordships, addressing the final submission, the order does not violate the provisions of the Disaster Management Act, as the NDMA has exercised the powers within the statutory provisions of the Parent Act. At the outset, the respondents submit that delegated legislations as a general rule are liberally interpreted. If in this case a strict interpretation is provided, it would defeat the purpose of the Disaster Management Act. The NDMA should be given sufficient leeway to make suitable decisions in the public interest so as to tackle disasters effectively. Your lordships, the NDMA has exercised powers within statutory provisions. If I may direct this Honorable Supreme Court to Section 2E of the Disaster Management Act. Here, the Disaster Management Act clearly establishes that disaster management includes the need of mitigation and reducing the risk of a disaster. Furthermore, Section 6 clearly, and Section 6 subclause 1 and 6 clause 2A of the Act clearly indicates that the NDMA is empowered to lay down plans, policies, and guidelines for effective disaster management. And most importantly, the NDMA can, under Section 6 clause 2I, take any measures towards preparedness and mitigation of a disaster as it may consider necessary. This implies that the NDMA has sufficient discretion to formulate any policy and guideline to tackle disaster effectively, and this includes the present order. Your lordships, the order has been issued so as to prevent the spread of misinformation, and this is a mitigating effect. Therefore, the NDMA's intent is safeguarded under Section 6 clause 2A and 6 clause 2I. Your lordships, the petitioners have also contended that Section 6 is vague. However, disaster and disaster management cannot be seen in a straitjacket formula. There is an imperative need to allow a broad reading so that the NDMA can tackle different disasters. As my co-counsel will also establish, the NDMA deals with a variety of disasters under the Act. Your lordships, the council also, your lordships, I have realized that the time has been exceeded. May I be granted 1 minute to rebut 2 more contentions?
Yes, quickly finish.
Indeed, your lordships. Much obliged, your lordships. Lordships, furthermore, the council has also contended that Section 24K and Section 30 are being affected by the impugned order. However, your lordships, the council has failed to understand that under Section 22 clause N, the State Executive Committee, if I may direct your lordships to 22 clause N, if your lordships are with me. The State Executive Committee, as its main function, has to provide information to the national authority related to different aspects of disaster management. And also under Section 30 clause 1, the lordship, it's clearly established that the functionings of the District Disaster Management Authority is subject to the guidelines laid down by the national authority under 30 subclause 1. Hence, your lordships, the contentions raised by the petitioners is not permissible. It does not stand in this regard. Your lordships, indeed, your lordships, if I may proceed to the conclusion. The council's...
Quickly now, you don't need to do that. You're running over time. Let the other one take over.
With this, the council concludes its arguments and yields the floor to the co-council. Thank you, your lordships. It has been an absolute honor arguing before this bench.
With the permission of this bench, this council will now present the submissions.
Yes.
Much obliged. Your Lordship, may it please the court. This is counsel number 2 appearing on behalf of the respondents, Union of Rashtra and others in the instant matter. This counsel for the next 14 minutes will be dealing with submission number 3, that is the order dated 1st June 2021 is not violative of the principle of federalism, and submission number 4, that section 6 of the Disaster Management Act is not unconstitutional. Turning to our third submission, Your Lordship, it has been established by the petitioners in page 9 of their written submissions, as well as in their oral submissions, that dissemination of information regarding public health in itself falls within entry 6, and therefore this order is violative of the principle of federalism. In order to counter the same, this council preliminarily submits that it is vital that this court recognizes that Rashtra does not follow the strict principles of the system of a federal governance, but that of a quasi-federal governance, as observed in the case of Kuldeep Nair versus Union of India and ITC Limited versus Agricultural Produce Market Committee. Now establishing how this order does not violate the principle of federalism, we will be arguing in a two-in manner that firstly, this order's substance and subject matter falls purely within the ambit of the union list or the concurrent list, and secondly, any encroachment into the powers of the state is merely incidental. Your Lordship, turning to our first one, it is the respondent's submission that this order, firstly, in its subject matter, involves the containment of an infectious disease. To this extent, we argue that this order falls within the ambit of entry 29 and 30 of the concurrent list, which provides that prevention of extension from one state to another of infectious or contagious disease, and vital statistics, including registration of births and deaths, respectively. Hence, Your Lordship, it must be noted that by looking at the hierarchy that has been established under Article 246 of the Constitution, which provides the central and the state governments with the ability to legislate on legislative fields held in the 7th schedule, the concurrent list, the ability of the union to legislate on matters of the concurrent list has a priority over the ability of a state to legislate on a concurrent list or the state list as well. Furthermore, Your Lordships, it must be noted that the petitioners have admitted that the Disaster Management Act was passed under entry 23. Admittedly, Your Lordship, the Disaster Management Act does fall under the legislative field of entry 23, which regulates social insurance and employment schemes. However, it must be noticed that it is a basic principle of interpretation of entries, as held in the case of Hari Krishna Bhargava versus State of Uttar Pradesh, that by legislating upon a particular field, the competent authority may rely on various other fields of legislation as well, which is what is being carried out in this case. And therefore, such a measure for the containment of COVID-19 is not in violation of the principle of federalism. Now, moving to my second limb, Your Lordship, that this is not, even if there is any encroachment, it's merely incidental. In order to establish the same, it must be noted that the Disaster Management Act in itself is formulated in a top-to-down manner, whereby the powers of the center, that is the National Disaster Management Authority, exceed the powers of the state and the District Disaster Management Authority. This is noticeable through sections such as Section 18, Clause 1, which provides the powers and functions of the State Disaster Management Authority is subject to the powers of the National Disaster Management Authority. Section 22, Clause 1, providing the State Executive Committee the responsibility of implementing the national plan, and Section 23, Clause 2, of drawing a state plan only in accordance with national plan. Hence, the vital question the court must answer today is whether, apart from these already placed restrictions on the Disaster Management Act regarding the powers of the state being subject to the supervisory role of the center, whether this order exceeds such restrictions and provides certain other restrictions which are violative of the principle of federalism. And it is our submission that even if it were to be contended that this order encroaches on the legislative field of public health information, which is not exclusively provided under the state list, this is a mere oblique and peripheral manner of invasion, as held in a case of Dr. J.L. Patil versus Chief Ministers, and is not one that reaches the threshold of being struck down merely on the grounds of federalism, Your Lordship. Hence, Your Lordship, furthermore, it can be noted that this order does encourage the spirit of federalism, as can be observed under Clause 2 of the order, which states that the states have the ability to regulate information within their boundaries, except that it must be submitted to the designated officer in case of inconsistency with the official data. Therefore, Your Lordships, in conclusion, as argued by my co-counsel under submission 1, this order is not violative of Articles 19, 14, and 21 of the Constitution of Rashtra. And under submission number 2, as argued by my co-counsel, that this does not violate the Parent Act, that is the Disaster Management Act, and as argued by this council, that this order does not violate the principle of federalism and therefore fails the duality test of holding this order to be unconstitutional. If Your Lordships have no further questions, the council will now proceed to the final submission.
Yes, please proceed.
Much obliged, Your Lordship. Your Lordships, it must be noted that the petitioners in this current case are contending that Section 6 of the Disaster Management Act is unconstitutional. And in order to substantiate on the same, they rely on 3 grounds. Firstly, that the order is in excess of the central legislative's competence. Secondly, the order must be interpreted in a harmonious manner. And thirdly, there is an absence of check on power of the National Disaster Management Authority. Your Lordship, primarily, we will be eliminating the ground raised by the petitioners on there being a manner of harmonious construction with the Epidemic Diseases Act. Your Lordship, it must be noted that under Section 72 of the Disaster Management Act, if I could read it out, this act has an overriding effect on other provisions, and to quote the same, the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or in any instrument having effect by virtue of any law other than this act. In observation of this section, Your Lordship, the contention of the petitioners that the Epidemics Act must be read in harmonious construction must be rejected. Furthermore, Your Lordships, the petitioners have also relied on the United Kingdom's Act on contingent containment of diseases. However, Your Lordships, it must be noted.
Just hold for a minute. One of the principal contentions of the petitioners, at least as we have understood it, is that the 1st June order is manifestly arbitrary, which means, amongst other things, that it is facially arbitrary. It's unreasonable on the face of it. And second, that there is no discernible nexus between the object and the notification itself. Now, you have to start with what is the object? What is it that you're trying to do? What is the evil that you're trying to cure? Because that's the object of the act. And how you go about it is the next question. Could you address that, please?
Your Lordship, while the proportionality of the order has been and the manifestly arbitrary nature of the order has been addressed by my co-counsel, in order to reiterate, with regard to the order being manifestly arbitrary, it must be noted that this order is subject to the powers of the Ndma of the Disaster Management Act in itself, wherein various procedural safeguards are provided. Furthermore, Your Lordship, it must be noted that the designated officer follows the principles of natural justice by recording reasons in order to determine whether the information is accurate or inaccurate and rejecting the order on this ground. Hence, Your Lordship, such an order is not unreasonable, as Your Lordship had asked for a clarification regarding a legitimate state aim. Your Lordship, the phenomenon of infodemics, that is misinformation during a pandemic, is an international phenomenon that is recognized by the World Health Organization itself, as well as this court in the case of Alok Alak Srivatsava. Hence, Your Lordship, such a manner of constraint or such a manner of regulation on information is not something unreasonable and is in furtherance of the legitimate state aim in order to protect its own citizens from the possible effects or the tragedy of misinformation, which could aggravate the situation, Your Lordship. Hence, if Your Lordships are satisfied with my addressal of proportionality with legitimate state aim and manifestly arbitrary, the Council will now proceed with the submissions of why Section 6 is much obliged, Your Lordship. Hence, Your Lordship, eliminating the argument of harmonious construction. This Council here now currently will be establishing how this order does not fall within the exclusive powers of the state list in itself, but is one that falls within the ambit of the central legislative's competency. Your Lordship, it must be noted primarily that as stated by the petitioners, that the pith and substance of the Act of Section 6 must be looked into. When the pith and substance of the Section 6 is looked into, it can be noticed that the Ministry of Home Affairs has in various instances laid down the types of disasters. And to name a few, Your Lordship, it is in the nature of climate-related disasters, geographical disasters, water disasters, biological and nuclear disasters, and epidemics and biological disasters being one of them, and industrial disasters. Your Lordship, the petitioners, by their own words, have conceded to how only the effects of the disaster or the effects of disaster management fall within the state's ambit. However, it is our submission herein, relying on paragraph 62 and 63 of our written submissions, that the ability to combat such a disaster and the disaster management in itself falls within the central sphere of legislation. To name a few, Your Lordship, something as basic as interstate migration and quarantine falls within entry 81 of the Union list. Prevention of extension of infectious diseases falls within entry 29, and regulation of highways in order for quarantine or road-related disaster falls under entry 23 of list 1, and even railway-related disasters and mine-related disaster fall within the Union list. Hence, Your Lordship, to this extent we submit that there is no encroachment into the powers of the state, as following the concealment, the petitioners conceding to merely the effects of the disaster management falling within their ambit does not make this section to reach the threshold of being struck down merely on these grounds. When Article 246.
Counsel.
Yes, Your Lordship.
Can you just throw some light on the interplay between the three lists in the 7th schedule?
Indeed, Your Lordship. Your Lordship, it must primarily be noted that the 7th schedule merely provides the field of legislation. However, the power to regulate or legislate on such fields follows from Article 246. Article 246 under Clause 1 states that the Union has the exclusive power to legislate on fields falling under the Union list. Article 246 Clause 2 states that the Union has a priority on legislating fields on the concurrent list, followed by the legislation of states in the concurrent list. Article 246 Clause 3 states that the states have the power to sole power to legislate on the fields falling in the state list. And Article 246 Clause 4 is a residuary clause that states that if the legislative field does not fall in any of the lists, the Union has the power to legislate on such fields. Therefore, Your Lordship, when such a hierarchy in itself is noted, it must be interpreted in such a manner that the Union faces a manner of primacy in legislating on fields which falls essentially within its domain. Furthermore, Your Lordship, if there is any manner of encroachment into the powers of the state, it is merely incidental in nature and is not to the threshold of being struck down on the matters of constitutionality. Hence, Your Lordship, this Section 6 is completely within the vice of the Union to legislate upon in furtherance of effective disaster management. Turning to the final limb, Your Lordship, wherein the petitioners have contested, there are no checks and powers on the National Disaster Management Authority. Your Lordship, herein it must be noted that the threshold for what constitutes a check and power is something as simple as Section 2, that is a definition clause of the Disaster Management Act in itself. For example, Section 2D that defines disaster states that the situation of a disaster triggers only when the affected community cannot cope with handling the disaster. Hence, in such instances in itself, a policy or a guideline can be laid down. Furthermore, the Disaster Management Authority is also headed by the Prime Minister as the ex-officio chief person under Section 30, which is a notable constraint and a procedural safeguard. However, Your Lordship, I would like to draw your attention to the case of CUPL versus Union of India, wherein Justice Ashok Bhushan held under paragraphs 36, 38, and 42 that the National Plan of Disaster Management in combating the COVID-19 pandemic in India was so full-fledged that the Disaster Management Authority has all powers to take upon in combating the pandemic. Hence, drawing relevance from this case, wherein the court observed that the National Disaster Management Plan and the policy read in consonance with each other is sufficient to lay down a policy based on which the center could combat the COVID-19 pandemic This in itself satisfies that there's necessary checks and balances on the National Disaster Management Authority, Your Lordships. Your Lordships, if Your Lordships have no further questions, the Council would now like to proceed to the prayer.
Yes.
Much obliged, Your Lordships. Therefore, in the light of issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before this honorable court to dismiss the petition and or pass any other order in the light of justice, equity, and good conscience. All of this most humbly and respectfully submitted before this honorable court by the Council on behalf of the respondents. Thank you, Your Lordships. It has been an absolute pleasure arguing before this honorable bench.
Thank you.
Thank you.
All right, we'll score. Justice Ahuja and I will go offline for a bit.
The petitioner had reserved.
Sorry, you had time for a rebuttal.
Okay, yes.
Yes.
Okay.
Yes.
Just a minute, Your Lordships. I'm so sorry. My internet is. I'm so sorry.
Take your time.
Your Lordships, first of all, I will address the contention of the learned respondents that the pith and with respect to the Section 6 constitutional validity in this present case. It has already been established that the pith and substance of disaster management cannot squarely fall within union and concurrent lists or state lists because the number of overlaps it has is manifold and spans across all various entries contained within all lists. At that point of time, they have simply relied on the principle of federal supremacy and said that in this case, the union's powers should prevail and the union should be granted legislative competence. However, the principle of federal supremacy can only be invoked after it has been proven that there is an irreconcilable and inevitable conflict between the state's exercise of power and the union's exercise of power. This was held by the court in West Bengal National Committee versus the Union of India, and also in the case of Rajendra Shah and another versus Union of India. At no point of time has the respondent side ever showcased to us as to what this irreconcilable conflict is and why states and the center cannot be given plenary and plentiful powers to exercise their rights equally and distinctly under the scheme of the current act. We have made reference to the Epidemic Diseases Act to show how it is possible for there to be such a harmonious construction where states and centers separately and distinctly exercise their powers. There has been no reason given as to why the Disaster Management Act, or specifically Section 6, cannot also follow a similar pattern. Secondly, with respect to the question of procedural safeguards that the respondent has raised, this has merely been asserted that Section 2 means that the Disaster Management Act can only be invoked in situations of disaster. And since the Prime Minister is the ex officio chairman, that this provides for adequate redressal in terms of providing procedural safeguards. This is completely against what has been recognized by the Court of Law as to what a reasonable safeguard actually is. A reasonable safeguard takes the form of due process of law, which includes the right to representation before an order passed by a organ of the executive, or actually prescribing censorship.
Counsel, all the cases you are citing are not situations of a pandemic like this one. So if you were to follow the due process of law, then you know what would happen, the manner in which you are suggesting. So you must appreciate that this is an unprecedented situation.
Yes, sir. Even if it is an unprecedented situation, then it is unclear to us how written approval given by the designated officer, which cannot be questioned post it has been given, is something that forms any form of procedural safeguard. Even if it is an unprecedented situation.
Who says it cannot be questioned? Who says it cannot be questioned? You have the writ jurisdiction, which you are already into.
Yes, sir, but at that point of time, it's too lengthy a procedure to go and appeal it before a court of law, especially considering under Section 71, appeals only lie to the High Court and the Supreme Court, not even to lower courts. At that point of time, that does not become an exercise of power that can exercise of reasonable procedural safeguard at any point of time. Yes, it is an unprecedented situation, but that does not mean that center and the executive can have unfettered powers to do as it wishes, as it was recognized in Ram Jethmalani versus Union of India, to achieve a quick and swift aim in terms of combating systemic disadvantages. People's fundamental rights cannot be arbitrarily curtailed to that extent. As my time has elapsed, I would like now to rest my case. It was an incredible honor to argue before your lordships.
Thank you.
Thank you.
Your Lordship, we had reserved 1 minute for sir rebuttals, which was provided for in our submissions. Is that all right?
Go ahead.
Much obliged, Your Lordship. Your Lordship, 2 points of sir rebuttals as raised by the petitioners. Firstly, with respect to the pith and substance of the Disaster Management Act and federal supremacy in itself. Your Lordship, as observed in the case of S.R. Bommai versus Union of India, there is no reason for plenary powers to be provided to the state, as unlike the state of United States of America, in India, central supremacy is recognized, as India follows the quasi-federal structure of model of governance. Furthermore, Your Lordship, while admittedly there is no entry providing for the pith and providing for disaster management in itself under the 7th schedule, it was the respondent's argument that the union has the sole power to decide and regulate on effective disaster management relating to various disasters, while as what was contended by the petitioners is merely the effect of disasters, such as trade and communications, falls within their ambit. Secondly, and most importantly, Your Lordship, with respect to procedural safeguards under the order, as has already been established by my co-counsel under his submission, that the order provides for a prior written approval to be submitted based on which the designated officer makes his decision. With this, the Council on Respondents rests their case. Thank you, Your Lordships.
Thank you. All right.
So we are going offline, sir.
Justice Ahuja and I are offline.
Offline.
Could somebody please just check whether you've received the submissions in the form? I've just sent mine in.
We'll do it, sir, right away. Your
Just
Lordship.
check and confirm and let me know. Just either call me on the mobile or something.
Yes, sir, we got it.
Okay, great.
Yeah, on there. No, you just call him in.
Your Lordship, Ahuja, have you sent the score sheet to us?
I can't hear anything.
Am I audible?
Yes.
Sorry, he's WhatsApped it to you.
No, just
Okay.
ask her to. Ask her to. Ask her.
Could we know whose number it's been WhatsApp
Yes.
to?
Abhay, to what number have you sent it?
1 second, I'll just ask the person. Just a moment, sir. I'll just find it. Just one moment. I'll just send it to one of my staff. She has the number of one of you. Who are these office bearers? Just 1 second. Can you just mute this? Kisko bheja hai? Kisko bheja hai?
So we got this question.
Got it? Abhishek, sent it to Abhishek.
Receive this question right now. Thank you.
Okay. Thank you.
Thank you for such an exhilarating round. We would now like to begin with the valedictory function. During the first segment of the valedictory function, our dignitaries will address the audience, after which we will proceed with the announcement of results. We have amidst us today Honorable Mr. Justice J.S. Patel, Honorable Mr. Justice Riaz Chagla, and Honorable Mr. Justice Abhay Ahuja, judges of the Bombay High Court, along with Senior Counsel Mr. Darius Kambata and Mr. C. Rashmikant, the trustees of the Chief Justice M.C. Chagla Memorial Trust.
Mr. Darius J. Kambata, trustee of the Chief Justice M.C. Chagla Memorial Trust, is a senior counsel who graduated with his LLM from Harvard Law School and was called to the bar in India in 1984. He was designated as a senior counsel in 2005 and practices before the Supreme Court of India, the Bombay High Court, and high courts and tribunals across India. He has also held 2 distinguished public offices, that is those of Advocate General for Maharashtra and Additional Solicitor General of India. Mr. Kambata has a large and varied practice and has played a role in constitutional, commercial, securities, and administrative law matters, and in significant domestic and international commercial arbitrations. He has held 2 distinguished public offices, as mentioned earlier, Advocate General for Maharashtra and Additional Solicitor General of India. It is an absolute honor to have you, sir, and we would request you to kindly address the meeting.
Thank you very much, Justice Patel, Justice Chagla, Justice Ahuja. First of all, thank you very much for being here and for the 2 of you judging this moot court competition. I'm sure it has meant an immense amount to the participants. Participants, the office bearers of the Moot Court Association, and friends. I think it's fitting that a competition of this nature is held in memory of the great Chief Justice M.C. Chagla, who was a man for all seasons and one of India's greatest judges. His early years, which were molded and fashioned amidst the spires of Oxford, saw him take a keen interest in debate. He tells us in his autobiography of his visits to the great Oxford Union and of waiting until 11:30 and 11:45 at night to get a chance to speak as a junior member after all the seniors had spoken. He was also the president of the Oxford Indian Majlis. And I think his formative years in engaging in those debates really molded his character for the rest of his life. He was one of the greatest votaries of free speech and civil liberties. And I think that for every student, particularly law students, reading Roses in December is almost compulsory. It's a most enjoyable book, actually. It's not a book of, in that sense, learning in the traditional style. You learn because of his experiences, the breadth of his interests, And it's just a very entertaining, great book to read. He was truly personified, to my mind, what Sir Walter Scott had always said, which is that a lawyer without any knowledge of history or literature is a mere working mason. If he has knowledge of, or some knowledge of these, he can aspire to call himself an architect. And I would wish and hope that the young lawyers of today aspire to call themselves architects, looking beyond just the black letter of the law into society, into issues and problems, into literature, into history, poetry, music, because that will complete and mold them. And I think participating in moot court competitions is really a fundamental part of the process of training to be a lawyer. It truly mimics what you have to do in real life practice as a lawyer. Much more value than sitting for law exams, I can assure you of that. And I say so with a fair sense of déjà vu, having been an active mooter during my college career as well. In fact, witnessing today's debate felt like I'd never been away, and I almost wanted to get into the act and moot with all of you. Because essentially, in real life law practice, you have a problem or a dispute, you have a set of laws or a legal matrix, and you have the all-pervasive element of justice and equity. And you as a lawyer have to fashion a solution from the perspective of the petitioner or the respondent, depending on which side you're on. And often there is not one single solution. You have competing and jostling legal arguments. You have these intersecting vectors of fact, law, justice, and you always have the most important factor in any case or dispute, the persona of the judge. You have to win and persuade the judge. And it's not a case of mathematics. You're being able to say 2 + 2 makes 4 doesn't win over the judge. You have to persuade the judge. And I saw that happening today in many respects. Of course, the role of a judge, I'm sure, is the most complex and the most difficult, because you have to find a solution ultimately at the end of very attractive arguments on both sides, as we witnessed today. The issue you had is really a real life dilemma. The contest between due process and free speech on the one hand, and tackling a disaster or disaster management on the other, is the latter a sufficient imperative to compel a curtailment or a suspension even of the former? That's a real life problem we face every day. Is the disaster management only a pretext, or is it a true reason why due process has to be curtailed and free speech has sometimes to be put on hold? These are issues which I'm sure all of you will grapple with when you join the profession. And I want to just end by saying thank you very much for this excellent spectacle we had today. I look forward to all this talent, exuberance, and sheer spirit coming in and pervading our courts and really being the hope of the future. Listening to a moot court like this gives me a lot of hope for the future. I think all of you did well. There has to be a winner, there has to be a loser. But I think just the way you participated, and I'm sure the other teams participated, itself means the system is the winner. So thank you very much.
Thank you so much, sir. It was an honor hosting you today. Honorable Mr. Justice Abhay Ahuja obtained his LLB degree from Government Law College, Mumbai, and his LLM from the University of Mumbai in the year 1994. He enrolled as an advocate on record for the Supreme Court in the year 2000. He was also a professor in Government Law College, Mumbai. Justice Ahuja was appointed as the Senior Standing Counsel by the Income Tax Department in the year 2008, as Senior Panel Counsel Group 1 by the Government of India in the year 2015, and as Senior Panel Counsel by the Insolvency and Bankruptcy Code of India in 2018, representing the government in many important matters till his elevation as Judge of the Bombay High Court on March the 4th, 2020. It was a pleasure to have your Lordship judging the final rounds. We request your Lordship to kindly address the audience.
Thank you, Abhishek. I was hoping my senior brother, Justice Patel, would do the honors but he has left this little job to me. Maybe he'll add a bit or more a little later. Honorable Justice Patel, my elder brother, Justice Chagla, Mr. Darius Khambata, the trustee of the MC Chagla Memorial Trust, office bearers of the Moot Court Association of the Government Law College, dear participants, students, ladies and gentlemen, good evening. It has indeed been my proud privilege to be here with all of you this evening. At the outset, I fully and completely associate with the sentiments expressed by Mr. Khambata. In fact, he has not left much for me to say because I have a similar point of view. The system is surely the winner. However, since I have been given the honor by my elder brother, I would say a few words. Having been associated with the GLC since 1989 as a student first, and then as an honorary professor from 97 to 2008, the association has been truly exhilarating. It's been a learning experience year after year with various moot court competitions and other activities to do with the college. Just as the baby in a mother's womb is nourished through the umbilical cord, the legal and the judicial profession in this city as well as in our country is being nourished by the GLC. These opportunities, like the MC Chagla Moot that GLC makes available to tap a student's potential, are so tremendous that it is no surprise at the galaxy of legal luminaries that have taken birth in its womb. I'm aware that every year the MC Chagla Memorial Moot competition is held, providing the participants as well as the students and the participating institutions exposure to high caliber courtroom experience supported by equally illustrious legal research, nurturing talent to produce leadership for the future. At this time, I'm reminded of what Justice MC Chagla has said in Roses in December. I would like to quote from page 346 of this wonderful autobiographical rendition. I quote, "Our education must produce leadership for the future. No country can be really great unless it has leadership. And education should always be aimed at the production of an intellectual elite. The pursuit of excellence in whatever work we engage in is among the highest of educational ideals. Opportunity should be open to everybody who has the capacity and the ability to reach the top. It was not enough to create a top. We must also create opportunities for everybody to reach the top." Unquote. So these were the thoughts of such an illustrious mind. He has written this portion in the part where he was education minister of this country after demitting office as a judge. He was also the education minister and he held many other portfolios and played many other roles. And I think, as Mr. Khambata has said, you should read Roses in December to encourage and rejuvenate yourselves. I think everyone must do it at any time, including many of the senior lawyers of our court. All right. Coming back to today's event, we have witnessed top-class presentation and preparation at all levels: comprehension, research, analysis, presentation, oratory, quick thinking. And believe me, when we went offline, it was so very difficult for both my elder brother, Justice Patel, and myself to decide. We were ad idem, but we said, look, there is a tie. He will let you know, I should not let the cat out of the bag. So that's his prerogative. Yes, there are certain specific comments, but I think I'll leave it for your mentors to do that, how to address the court, I know you have the pressure of completing your arguments within the time. And as judges, we would always interrupt you. But you should not get affected by that interruption and stick to your point. I think most of you did that. You guys are very good, extremely good actually. And all of you have the great potential to become very good leaders, as Justice MC Chagla would have desired. Also, before I forget, my compliments to the framer of this moot problem. I think it was very relevant for the times. My shabash to the students who have toiled to prepare the outstanding bench memorandum. That was quite helpful for us. Keep it up. It was great being all of you this evening. Wishing you all the very best. Good night. Thank you.
Thank you so much, Your Lordship. Born in Mumbai on 26 April 1962, Honorable Mr. Justice G.S. Patel is a graduate of St. Xavier's College and Government Law College. He started practice in 1987 in Mumbai, working on commercial, corporate, and civil litigations, and also appearing in a large number of environmental public interest litigations. In 1994 to 1995, Mr. Justice Patel received the first international fellowship at Pacific Energy and Resources Center, California, in environmental law. His lordship served as the honorary secretary of the prestigious Bombay Bar Association for 2 3-year terms from 1999 to 2005, and served on the association's standing committee till his appointment as a High Court judge. From 2008 to 2011, he was a part-time lecturer in administrative law, constitutional law, and environmental law at Government Law College. His lordship was elevated as a judge of the Honorable Bombay High Court on 21st June 2013. He has also served as a trustee in several public charitable trusts and foundations in the fields of education, environment, and for the hearing impaired. It was an absolute honor to have you, Your Lordship. We request Your Lordship to kindly address the audience.
All right, thank you for that introduction. It was brilliantly copied from somewhere on the internet. None of it is original. I'm going to be very, very brief about this. One, I must tell you that there's a side to Mr. Khambata that you do not know. He can be extremely devious and sinister, and I am one of the victims of that. He's been pushing for me to be a judge for a very long time. When I said, why not you, he weaved and ducked and shoved me into this position. So if I'm here, he has something to answer for. Second, he was also responsible for what's happened more recently, which is the chairmanship of the Government Law College Governing Council. That's actually a great honor. And I think we're making some progress there with the new principal and so on and so forth. So that's actually an excellent thing. All right, second thing is that I have to tell you that I'm beginning to dislike these moots very much because they remind me more and more of my own shortcomings and inadequacies. I'm extremely glad that I'm not in competition with any of these people. I wouldn't have made it. Their standards are now so high, and I think Darius will agree that they are well above anything that we did or saw being done at the time when we were in fact in GLC. In fact, one of the first moots I attended was one where Darius was arguing as it happens at that time. The standard was exceptionally good. You'll see this in the results. There's just one quick observation. You know, you're in a court. You don't refer to yourself as the third person, as the counsel. I mean, you leave that to Julius Caesar or whatever it is. It's you, so there's no problem in using a personal pronoun, I, and get on with it. And for heaven's sake, don't waste time reading the prayers because we know what you're here for. The prayers are already there before us, otherwise we wouldn't be hearing you. The last thing I wanted to say is that just underscore what Justice Ahuja said. We are here to make a nuisance of ourselves to some extent. We try and control ourselves, but that's why we spin these googlies at you. They're really not intended to lay down the law, but they're really intended to throw you off balance. And the test is to see how well you withstand what's coming at you pretty much body line. On that score, all of you did exceptionally well. And I want to suggest to this Moot Court Association something radical. Start small, but try this. Try a moot court where one of the students is the judge and have him render a decision. That's really the tricky part. And tell him to give you reasons for his answer there and then see what you produce out of GLC. All right, let's get on with the list, please. Thank you very much.
Thank you so much, Your Lordship. We would now like
That's
to
another thing I
invite.
don't like. Stop using that word. At least with me. All right, come on.
We now like to invite Senior Counsel Mr. Darius Khambata, Trustee of the Chief Justice MC Chagla Memorial Trust, to kindly present the awards for the Best Memorial and the Second Best Memorial.
So I have here the results for the Best Memorial, and it is Team K, School of Law, Christ University, Bangalore. And I'm going to read out the names of the participants of that team: Vishnu Mohan Naidu, Adhyayam, and ICD Raj. Do I go ahead with the second best memorial? Yeah. So the second best memorial goes to Team B, the Jindal Global Law School. And the participants are Apurva Saraf, Sharan Sampat, and Shubh Jaiswal. Congratulations to all of you.
Thank you, sir, and congratulations to the winning team. We would now like to invite Honorable Mr. Justice Abhay Ahuja to kindly present the award for the Best Speaker and the Second Best Speaker.
All right. The best speaker is Team K, Vishnu Mohan Naidu, School of Law, Christ, Bangalore. And the second best speaker is Team P, Samaira Adlakha, Nalsar, Hyderabad.
Thank you, Your Lordship, and congratulations to all the winners. We now come to the most anticipated moment of the evening. We request Honorable Mr. Justice G.S. Patel to kindly present the awards for the best team and the second best team.
You've given me the aggregate totals. Just WhatsApp them to me, the aggregates. No, so that there's, okay, 1 minute, you just mailed it. 1 minute, hang on a minute. I thought you'd send it by, hold on. Yes, so here we go. The winning team for 2021 is Team J. The runner-up is Team K. Well done. Congratulations to both of you. That was excellent.
Thank you so much.
Heartiest congratulations to all the winners. Wish you all the very best.
And incidentally, there was no real disagreement between Justice Ahuja and me on the scores, individual scores either.
Actually, there was none. There was none.
None. Not in the sequencing.
Your ad item.
Thank you. And congratulations to the winning teams.
Team
This edition of the competition.
J is from GLC, is it?
Yes, sir.
Okay, so we didn't know that, okay?
We don't know that, yes.
This edition of the competition has witnessed teams from across the country, including Pune, Nagpur, Ranchi, Bangalore, Lucknow, Hyderabad, Delhi, Chennai, and many more. Congratulations to both the teams and the participants. Their days of hard work and sincere effort have finally borne fruit.
The General Secretary and Assistant General Secretary of the Moot Court Association of Government Law College, Mr. Abhishek Raj and Mr. Ruhan Shah, have efficiently guided us through the process of this moot court competition. The success of this prestigious competition can be attributed to their dedication and perseverance. Through this strong leadership, the Moot Court Association has achieved higher standards of excellence in all our endeavors. We now request Mr. Raj and Mr. Shah to give the vote of thanks.
Honorable Mr. Justice G.S. Patel, Honorable Mr. Justice Riyaz Chagla, Honorable Mr. Justice Abhay Ahuja, Mr. Darius Khambata, trustees, faculty members, participants, ladies and gentlemen. It has truly been a privilege for the Moot Court Association of Government Law College to organize and host this event in the memory of the late Chief Justice, Mr. M.C. Chagla, one of the greatest legal luminaries to have graced this coveted profession. The growing stature of this event bears testimony to the constant support, encouragement, and dedication of a number of people. This competition would truly be incomplete without acknowledging the efforts of these individuals. Firstly, on behalf of the Moot Court Association of Government Law College, I would sincerely like to thank Honorable Mr. Justice G.S. Patel and Honorable Mr. Justice Abhay Ahuja for sparing their valuable time this evening and judging the final round of arguments. We are indeed eternally grateful to your lordships for your constant cooperation, support, and guidance. Secondly, the transition from a state-level competition to a national-level competition and the growing stature of the prestigious Moot is truly an outcome of the broad vision of the Chief Justice M.C. Chagla Memorial Trust. I would like to extend my heartfelt gratitude to the trustees, Mr. Iqbal Chagla, Mr. Jahangir Chagla, Honorable Mr. Justice Riyaz Chagla, Retired Honorable Mr. Justice B.N. Sri Krishna, Mr. Rashmikant Dakshini, Mr. Darius Khambata, and Mr. Shyam Benegal for their consistent support and dedication towards the success of this competition.
We are truly grateful to Mr. Iqbal Chagla, trustee of the M.C. Chagla Memorial Trust, for his undying benevolence to the institution. This event would not have been possible without the relentless guidance and support of Honorable Mr. Justice Riyaz Chagla. His support to the Moot Court Association and Government Law College in organizing this prestigious competition during the pandemic on an online platform has been invaluable. I would also like to thank Mr. Darius Khambata for his support towards the organization of the competition over the years. I'd also like to thank Principal Ma'am Dr. Asmita Vaidya, Professor Rachita Rathore, Professor Kishu Daswani, and Professor Malika Devendra for being a source of inspiration and for the continuous encouragement of student activities in the college. The Moot Court Association is forever indebted to them for their immense support. Professor Sonali's Mathur contribution and significance to the Moot Court Association is difficult to express in a few words. Constant commitment and unconditional support to the Moot Court Association goes a long way in ensuring the success of all our endeavors. We must thank Mr. Rubin Vakil for drafting the case study for the competition, and Ms. Muskan Dadia and Mr. Rajveer Veera for drafting the bench memorandum. I must also thank Mr. Tushad Kakalia, Arzeen Ansari, Mr. Kunal Kataria, and Ms. Rusika Hari for judging the memorials for the competition. I would now like to thank all the members of the Moot Court Association for their constant devotion towards the success of this competition. In particular, I would like to thank the Assistant General Secretary, Mr. Rohan Shah, and the other office bearers of the association, Ms. Shakshi Shetty, Mr. Rajveer Veera, Ms. Lubaina Sutarwala, Ms. Muskan Dadia, Ms. Pushka Mani, and Ms. Shreya Bora, Ms. Benaisa Hansotia, Ms. Riya Doshi, Ms. Riya Nari Shanya, and Mr. Raman Sarai. I'd also like to extend my heartfelt gratitude to the former General Secretaries, Mr. Yash Ralkar, Ms. Anjali Karunakaram, Mr. Bharat Mirchandani, Ms. Ruchi Vagralkar, and Mr. Devavrat Nimbalkar for their contribution and support to this committee. The advisory board of the Moot Court Association, comprising of Mr. Rubin Vakil, Mr. Feroz Patel, Mr. Shanay Bafna, who have been a constant pillar of support and guidance. Their unending dedication to the Moot Court Association is irreplaceable, and I would like to express my heartfelt gratitude to them for their immense contribution. Finally, I would like to extend my gratitude to all the teams that have participated in this competition from across the nation. We look forward to hosting you again, and I truly hope that all participants have found this to be an enriching experience. Thank you.
Thank you, Abhishek and Ruhan. Sorry, sir, did I cut you off? Okay. With this, we hereby conclude the valedictory session of the 28th MC Chagla Memorial Government Law College National Online Moot Court Competition 2021. Thank you so much and have a